or any misdeeds were done by the insurgents groups. Human rights activities are generally difficult to give response or give the judgment on that. So how many of us among the lawyers could give response on that regarding the miscreants? So people talk about why concerning human rights, people consider only the civilian people, not only the army groups.
See, this is exactly you must understand. When a poor man is killed, then no one, government doesn't give him help. Then no one will help him. Then of course, if human rights activists can go and help him. When a police officer is killed, the police is there. They take action immediately. Human rights defenders need not go. An army officer is killed, the army is there. The army officers are there. And they are there to take this exactly. When this letter came to Mr. Kadamani, which was quoted here, this is a kind of thing is all where I get such questions even in Bombay. Sir, you have not said a word about a known gunda, a mafia, for example, shoots at a police officer and he is killed, and you have not raised your voice against them. I said, don't have to raise your voice, because the police is there to protect him. The police is there to fight his cause. But what happens is, people who are marginalized, people who are here, for example, people who have been tortured, people who have suffered humiliation and all sorts of humiliations. Now, there is no one to support them. It is there, the human rights defenders go. We don't have to go. We take care of only those who cannot take care of themselves. That's the basic principle of human rights. Not that today somebody in the government is attacked, of course. They have got their guards, the security guards, so many things are there. That we don't have to, we have no role to play. Because they are there, there are enough people to protect them. So only where protection is not there and absolutely helpless. Suppose like an army officer come and say, my army is not defending me. This is the violation I will suffer. No government is not protecting me. No officer is helping me. The government is not giving the support to the police to prosecute. Okay, perhaps we may take up this cause. Because there is injustice done to him. But where such protection is there, human rights defenders need not go there.
And one more thing I would like to add in this point. There are two different things between the security forces and insurgents. All the members of the insurgencies are banned by the Unlawful Activities Prevention Act 1967 and Section 3. They were declared as the unlawful organizations. And the army peoples, police and other security forces are in the lawfully established government. They are the members of the lawfully established government. So there is always two different meanings. One lawfully established government members, one unlawful organization. So we are always to protect the human rights from the hands of the state defense mechanism. That means security forces and the police forces, etc. And these underground peoples, they are unknown peoples. We do not like to we do not like to fight against them, or we do not like to fight for them also. If someone in the encounter, some underground people were killed by the security forces, we have nothing to say. And on the other hand, if some underground and the army peoples were encountered themselves, if the army people died, we have nothing to say. So we are more concerned to the laymen, to the people who are helpless from the hands of the state forces. This is the different. That is why I would like to mention that somebody, always some woman also emphasized that why you do not protect the lives of the army people. Justice as rightly pointed out that they have their own protectors. Their generals are there, their police officers are there. So why should we protect the rights of the armed personnel? Or why should we protect the rights of the police officers? They themselves are the protectors of the human rights according to the law of the land. This is my humble opinion. Thank you.
It should not be prepared that we support any killings. I make it very clear, no human rights activist would support any killing, either by any man or by any officer, anyone. For killing is, of course, we will never support. But what we are trying to say is, if an innocent man is killed and there is no one to defend him, if we can take up, we take up the case of that innocent man. That's the basic approach.
With due respect, though there are defenders for those police officers when he is killed by some unidentified force without. But can we defend the life of the police from the life of the civilian in the eyes of the police?
You are trying to say what at the time of killing we can go and protest at that time or after killing?
After killing.
After killing, the state is there to prosecute. The state is there, state will take up the case, police are there to investigate, they will arrest the man, whoever has done it, and maybe they will try that man. We don't need to do that anything. What are we to do that? What role we have? Of course, you are a lawyer, suppose you are a lawyer, and that innocent man, that insulted or somebody was killed, a police officer, he comes to you. Now, at that stage, you will decide. You have two roles. One as a lawyer. As a lawyer, you can't judge whether a client is guilty or not. That's the basic principle of any lawyer. It is for the court to decide. But you have a right to defend. You feel, okay, I take up the case. Because not that everyone should do human rights first. No. I don't say, it all depends upon the situation. You may accept a case of a known criminal. And you say, he has come to me as a client, I accept this case. You defend him according to your best of your abilities. And ultimately you will succeed in that sense. That's the role of a lawyer. See, you are not to judge and say, look here, my client is already guilty, but I am saying, no, that's not for you to say. It's for the court to say whether he is guilty or not. Your role is to defend him if he is your client. That's all. You can certainly accept it. Who says you should not accept? That's what says the lawyer.
My point is this, isn't that his right is already, his life has been violated.
His life has?
The life of the police officer has been violated.
Yes, so what? Ultimately, it depends upon something. See, and then what you as a student of law, what you study. A kills B. That's the one, if you are a professor of criminal law, he will tell you. A kills B. What the offense A has committed? A layman will say A has committed murder. You as a lawyer would know it may amount to murder, it may not amount to murder, it may amount to homicide without being murder, it may amount to grievous offense, grievous injury, or it may amount to simple injury, or it may amount to nothing. You as a lawyer knows that. So you have no right to judge. In such a case, it is for the court to decide. You defend a man, that's all. Defend a man if he comes to you. You may say, well, I don't want to defend because I feel this officer is wrongly killed. Okay, return go to some other lawyer. There is no human rights issue involved in a situation like that. Because as far as the police officer is concerned, there is a government which takes care of the police officer or is kicked and killed. The government takes care. You have no role to play. Except as a lawyer, you want to take up the case or not take up the case.
That means two things are there. One thing is the criminal act, and another thing is the violation of the human rights. So that point is in the form of criminal. It can be filed an FIR against the wrongdoers. This is the thing. One thing is the criminal act, and another thing is the violation of human rights. There are some difference between these two. A man may kill a man. A may kill B. Yes, you may say that A violated the rights of the life of the B, but this will come under the purview of the criminal law, not to the purview of the human rights. A wife may kill his husband, her husband. A husband may kill his wife, but this is the act of the criminals. This is not included in the human rights violation. Human rights violation is other things, and the criminal acts is another things. This thing I would like to clarify.
If there are no further questions, just another practical announcement. We thought there will be a slight change in the program that we have circulated previously because of the constraints of time, and we are also supposed to do an interim report before the Justice and College and on leaves tomorrow. We are planning to shorten our program a little bit and also the lecture in the bar, we are thinking of skipping and rather have a lecture here itself in the conference hall in the post-lunch session, since many of our papers have also not reached us and the discussions are also short. And I'm sure all the interested lawyers are also present around the table. We can have the lecture of justice right after the lunch break, and we can also interact probably on the basis of that if we have time a little more on that. And we would like to take the whole day tomorrow, which is of course a half day for the preparation of the report and the press conference. If there is no further discussion, the lunch is ready, and maybe we can all fill ourselves up, have a little more energy, and have some vigorous discussion before the inquiry panel concludes. So we can come back the moment we finish with the lunch. We can come back by 1:50. Is that okay for everybody? We come back at 1:15. Lunch is at the lounge downstairs.
Friends, at the outset, let me say my appreciation in calling me here and in appreciating whatever we are doing. That's more important. Because you are trying to understand what we are doing here. So I think I must thank you for that. Of course, when I came here in Manipur, I read today Land of Jewels. That's what I read. I put Manipur, Land of Jewels. But I come from a city called City of Gold. Bombay is known as City of Gold. There's an excellent book by one Gillian Tyndall, who gives the history of City of Bombay. The title is City of Gold. There's a place called Sonapur. Sona is gold. But only the tradition of Bombay is, so you earn gold there, you have plenty of gold. But you can't take gold away from Bombay. You spend, actually, that's a city where you spend also. You earn, you spend. So that's how it is described in that book. So I think I come here. I think the jewel, it was the land of jewel. Today I don't know what has happened to this beautiful city. I remember when I think of Manipur, I mean, it goes back. We remember the Manipur dance. That's the one thing which we knew all over the country. Manipuri dance. I think that was one thing we were appreciating. And of course, it's only when we come here, totally today, what people are going through, that kind of feeling we get. Because I'm a retired judge, I always say, when I say I'm a retired judge, I always say I'm not a tired judge. Because I've been doing whatever I can do. I believe in that kind of thing. Because I'm also a judge in the sense of, I use my time, my knowledge whatever I can do in the cause of the public, whatever I feel deeply, I don't hesitate. I join, I take part. This is what I've been doing in Bombay. Of course, we are having this kind of public hearing. We had a number of public hearings in different parts of the country on different issues, where we have sat and heard and talked to people. And this reminds me of what Lord Denning said once. What he said was, judges do not speak as actors do to please. Judges do not speak as advocates do to persuade. Judges do not speak as historians do to take the past. Judges speak to give judgments. I'm a retired judge, so I give no judgment. But in a public hearing, when I sit at a public hearing, I think there is always a verdict. There is a verdict must come. And that's what we did in Bombay. When the riots broke out in Bombay, large number of folk, everywhere misery, misery, misery. People are being killed, properties are being destroyed, and government was not doing anything. Government was not controlling. And in such a situation, our reaction was, we should do something. That's how we felt. And myself, fortunately, we had another judge by name Justice Dowd. He's still there, he's still active. He's one of the other judges that we have in Bombay. He was active in all human rights work. So we went around, talked to the people, and we brought a report, talked to people, record evidence, and finally we brought a verdict. We sat in a public meeting, and we said, here is our verdict. We called it the people's verdict. And we exposed what how the government has failed in controlling the matter. We exposed the police who were responsible for the death of so many of them. We also exposed the leaders who instigated the mass to kill each other. We didn't spare any of them. We exposed them completely. Because then the government took its own time to appoint a sitting judge, Justice Sri Krishna, to hold a public inquiry. And that is how he heard the parties like your judge here, Judge, what's his name? Upendra, I think. Upendra. Yes, Upendra is doing. Similarly, Justice Sri Krishna heard the people, heard the men, the parties that came before him. It took 6 years for him. We did the work in 6 months. Because we went to the people, talked to the people as we come here, talk to the people, go around, went to the villages, wherever atrocities have taken place. Because wherever we go, we have noticed things come from the heart. Somebody asked yesterday that you have not heard the government, you have not given them a notice. Yes, we have not given a notice, but we believe when we go to see people, talk to people. For example, we met Pranam Singh the other day. Pranam Singh, we met. I think, why should Pranam Singh tell a lie? He has no grudge in the army. He is not involved in politics. He is not involved in extremist activities. He is the one, he showed us how the intestine still protruding out. His suffering is unimaginable. And what has the government done? What has the police done? The man gets no justice. Now this is when he comes and tells, this is what I suffer. Well, there is no reason as to why we should accept. Or for example, the brahmachari was just shot for no fault of his. He was in the shop and one fine morning, what is it, Tera at the massacre. He was just shot for no reason. But this kind of thing. So we, by and large, believe that when they come in a sitting like this, in a public hearing like this, organized by people who have credibility in the human rights field. It's not, Bablu is not doing for his personal service. He gets no benefit of this. We are not doing for anything personal. There is nothing personal. Nobody is interested in personal motive. Nobody is interested in personal politics. Nobody is interested in making money or anything of that kind. So in a situation like that, we come forward and listen to the people. People pour out their hearts, and that's how the truth comes before us. And we record that. Tell the public, tell the people, look here, this is what has happened, do something. That's the basic approach. This is what we did at a number of places, and that is how we brought the people's verdict. Since then, of course, I've involved myself in so many reports. And everywhere, I can tell you, for example, recently, last year, I went to Tamil Nadu, where there is a place called Tirunelveli. Now what happened was, there was a tea garden. There were bonded labourers, quite a number of them, and they were not given salary. They were treated like they were years together. So recently somebody went there and found out that they are mostly Dalits, helpless people, treated as bonded labourers. So they organized them. He organized them to fight against the management and see that they get adequate, proper salary. So the tension started as a result of that. And one fine day, what they wanted to do was to give a memorandum to the collector, local collector of that particular town. They were not holding a demonstration. They had no arms or anything of that kind. They went in a procession, about 300 or 400 of them. From the railway station, they gathered, walked all the way, about a kilometer, to the collector's bungalow. They want to give a collector, look here, these are our demands, please send this to the government, please look into it, and so on. That was the thing they wanted. As they were nearing the collector's place, they were stopped. And they were stopped by the police, and they said, no, you can't do that. They said, we only want to give, we don't want anything, we want to give this memorandum. Collector, the police said, no, nothing of that kind. The result was, the police started lathi charge. And as a result of that, they rode to the high level, they had to jump down to save themselves, about 15, 20 feet down, then they had to run. And there's a river called the Tamraparni river, and the police started chasing them. And the police started chasing them, and they beat them mercilessly. And as a result of that, 17 people were killed in Tirunelveli town. And again, what did the government do? Government would not take any action immediately. No prosecution was not taken, a police officer, nothing of that kind was done. So again, we went as a human rights group, we talked to the people, collected evidence, they told us, they took us to the place where the incident took place, we brought a report, and that report we submitted in a month's time or 2 months' time. Now the government has done what? The government appointed a retired judge of the Supreme Court, or Justice Bond, to conduct an inquiry, official inquiry, under the Commission Inquiry Act. Now, it's more than a year and a half. The inquiry has not been fully done. The report has not come. I don't know why it is delayed. Perhaps there is some obstruction somewhere from the police or from the government or something like that, and nothing is coming. So this is exactly what is happening. Wherever the commissions of inquiry was resorted to. By and large, all governments have used the commission inquiry as a shield. People criticize, the press criticizes, public criticizes, any such action takes place, violating human rights on a large scale or anything of the kind. It comes to the press. The government has no answer to give. In such a situation, the government takes advantage of this commission's inquiry and say, look here, we are appointing a retired judge or a sitting judge to conduct an inquiry. So please don't comment on it, don't say anything. Then whenever you ask any question, the answer is no. The answer, the government will say, no, matters under inquiry, don't ask us. So people are silent. People are silent against protesting. People could have continued to protest. People could have done something more. No, they are all silent by appointing this commission inquiry. Now what happens in the commission inquiry, in all the cases, this is what I want to point out. By and large, in most of the commissions, under the Act you see, the inquiry can be private, inquiry can be public. Most of the cases, inquiry is conducted in a publicly. In the sense, it's not a private inquiry. I think in Upandra was a conducted inquiry publicly. They are not a private inquiry. So in a public inquiry, evidence is taken in the public, lawyers appear in the public, witnesses are examined in the public, cross-examined in the public, and finally arguments are heard in the public. So at the end of it, the inquiry commissioner or the officer makes a report. And I posed this question in Bombay, why should the report be confidential? There is no provision in the Act to say that the report must be confidential. There is no provision at all. It is left to the commissions of inquiry or the officer concerned to what he should do. But by and large, the tradition, I don't know how it has come, Report is made, it is sent to the government in a sealed envelope. Now Justice Sri Krishna, when he conducted inquiry for 6 years, every day, one item, what happened before Justice Sri Krishna, about 2,000 witnesses appeared before him. Large number of statements were recorded. And it's because, one of the largest and one of the worst riot that we had in Bombay, over 1,000 persons were killed. As I said, the property was about 4,000 was destroyed. 1,50,000 people had to leave their homes and run away. All sorts of tragedy, all sorts of misery. So it was one of the very tough inquiry. And as I said, about 1,000 or 2,000 witnesses had come and given their statements. Now, so evidence was recorded, inquiry was being conducted. Every day, the learned judge gave up his other work of the court. He was doing all, he's a sitting judge, only 10 days work, 11 to 5. And every day, the papers were reporting. The papers were reporting evidence. The papers were also reporting whatever the judge observed orally, his reaction, his comment, whatever he said was being reported in the press. And yet, with all that, what happens is, when the report is made in confidence. Report is not given to the public. And I posed a question openly in a public meeting. I also wrote an article later on in the Times of India in Bombay as to why should the report be confidential. So there is no provision. The only answer when I talked to the judge was, well, that was the way judges had done it in the past. Judges had never given a report publicly. So I said, if that is sort of a tradition, how to get over that? So I said, judges must be bold enough to say, well, I heard everything publicly. It was not a private inquiry. I'll make a report public myself. Judges should be bold enough to do that. I wish Upendra is bold enough to do that. He can give a report. Here is the report. Government is not. I am giving to the press. Action, of course, to be taken by the government. On the report, the law is, after submitting the report, within a period of 6 months, the report shall be placed before the assembly with an action taken report. That's it. That's the law. In other words, a report is submitted to the assembly. The government submitted to the government must consider the report, must say what action the government wants to take on the report, and then that must be placed before the assembly within 6 months. The law doesn't say that for 6 months the government can hold on to the report. There is no such provision at all. What the government has to do is, within 6 months, the government must tell the assembly, here is the report and this is the action that we have taken. Action taken report must be placed before the assembly. That is the law. So I said, since that is the law, government cannot wait for 6 months. Government either should release the report openly, or the public should have a right. Of course, somebody filed a writ petition in Bombay, because by the time the writ petition came up for hearing, the 6 month period was almost over, so the report was kept in the assembly. So naturally, of course, members of the assembly saw that. That's how the public got the report. I said in a meeting, there are one or two ways. So one, of course, the judge should be bold enough to give the report. I said, somebody asked me, what would you have done if I were appointed as a commission, as an inquiry officer? I said, I would have done a thing in a little different way. As a judge, I have given judgments in the open court. I have never dictated any judgment in my chambers. I had always dictated judgment in the open court. I had a loud voice, as you can make out. And so actually those days there was a joke that my voice was so loud because I dictated a judgment in my court that I was acquitting an accused. In the other court, the judge was dictating a judgment at such a low tone. The stenographer was taking down and he could not hear what the judge was saying. He was convicting, but what he heard was acquitting. So he wrote he was acquitted. This was a joke. But I was known for my voice. But I tell you, that's the equally important thing for a judge. Judge must have a voice. Because justice, the litigate, I tell you something more than that. But I'll complete this part. So I said, I dictate judgment in the open court. I said, if I were the inquiry officer, I would have heard the evidence in public, I would have recorded everything in public, I would have dictated judgment in public. I would have dictated a report in public. And the press would be there in the court. I would ask the press if they heard properly, report whatever they heard. The report could have been automatically published. So this is a thing which I think judges can revoke. Commission inquiry of but report is okay. Next inquiry, government will not appoint this particular Mr. Upendra. Doesn't matter. But you have done your duty. See that is given to the public. Inquiry is conducted not for government benefit. Inquiry is conducted because it is a matter of public interest. The public have a right to know what is the inquiry report, and you can't keep the matter pending without disclosing to the public. And that is against the spirit of the law. So this is what I said there. I said the best thing is to dictate the report in the open court. Just to conduct the whole inquiry in the open court, dictate the report in the open court, the public would automatically know about it. So this is what I was telling. The one commission inquiry, therefore, now what's happened in Bombay, I tell you. Justice Secretary has come to the same conclusion as we have come. He has identified the officers who are responsible for various atrocities they committed. He has identified the leaders who have done various atrocities, who are responsible for the riots that took place. So he has suggested action be taken against them. Because government is not taking any action. Earlier there was the BJP Shiv Sena government. He has passed strictures against the government. He has passed strictures against the Shiv Sena leaders and the BJP leaders, so they would not take any action. So the present government, of course, in the election management said they will take action. But now it's more than a year the present government has come. Earlier 1 year the earlier government. Now for more than 2 years now, no action has been taken. By and large, this is our experience. Wherever such commission inquiry is there, inquiry is conducted to take time, shield from the public criticism. Take advantage of that. Don't place it before the public. And finally, don't take any action. This is the unfortunate thing because the matter is pending in the Supreme Court. Somebody has filed a writ petition in the Supreme Court to say, direct the government to implement the report. Direct the government to take action on the report. Because that is pending for more than a year in the Supreme Court. I don't know what the Supreme Court will do, what the Supreme Court will say. We don't know. But I think in all these matters, ultimately, what matters is the public opinion. Public must assert themselves. This is what we have been doing in Bombay. We had a number of meetings where, irrespective of the fact whether the government takes action or not, we openly say what the government is doing is wrong. And this is what we are trying to do. And this is one of the things that came to my mind when we have commissions of inquiry, 4 reports or 5 reports, no action has been taken, nobody knows what has happened and so on. Of course, the other thing which we have been doing is the judicial inquiry through the court. I think that in a situation like yours, I think that is more appropriate because here I can see the stifling atmosphere that we see in this city, in Manipur. I think your difficulty is the judiciary has to be more active. It's only when as long as judiciary is active, as long as the judiciary is bold, things can be done. That, of course, we had an example of this, the magistrate who was tortured, complained to the High Court, and still, of course, 1995 or 94, the report is there. 6 years are almost over, and the High Court did not feel it necessary to have the report placed on the board and take action. Now that, of course, is a very sad reflection on the court. This is what happened, and we always feel sad about it. The other thing which I want to tell you is about the National Human Rights Commission and I think your Manipur Human Rights Commission. I think your Manipur Human Rights Commission, Mr. What is his name, Mr. Lava. I think he is doing an excellent job. I have not seen another Human Rights Commission doing as much as this Mr. Lava is doing. I can tell you openly. I was seen in Tamil Nadu that the State Human Rights Commission is there to do nothing. Because under the Protection Human Rights Act, there is one provision. Namely, if there is an inquiry or investigation pending, then they are not supposed to hold an inquiry. This is a very convenient way of doing things. Suppose there is a more serious violation of human rights, what the government does is, when government feels, okay, National Human Rights Commission may come, or the State Human Rights Commission may come, or something can happen. So immediately what they do, they announce, no, we intend to hold a public inquiry through a retired judge or sitting judge. Okay, we go into silence. moment this is announced, the Human Rights Commission say, well, I can't do anything because government has announced an inquiry. This kind of attitude. Now the result is the local Human Rights Commission. In Maharashtra we don't have Human Rights Commission. We still have the National Human Rights Commission. We don't have the local Human Rights Commission. The result is what happens in a situation like this. Human Rights Commission is prevented from stepping in. So what is required is ingenuity. Ingenuity on the part of the Human Rights Commission as to what one should do. And here I found Mr. Lava is doing that. He knows he has no power to go into what the army is doing, but he can certainly look into what the police is doing. And yesterday he explained to us, I think admirably, I really compliment him, how and what way they could do, whatever they could do, limited, of course they can't do beyond that, but he has done it, and I must compliment him. But what I feel sad about is that he has forwarded a number of reports to the National Human Rights Commission, and it's unfortunate there is no response from the National Human Rights Commission. Under the Act, National Human Rights Commission also has no powers to hold a regular inquiry against atrocities committed by the armed forces. They can't do that. Under the Act, they can only call for a report from the senior officer, and the report can be seen. They can't even question the report. They can give some commentary on that, some observation, and send it to the government, and that's all that can do under the National Human Rights Commission. Now, with the result, and wherever our atrocities committed by the armed forces are concerned, we have hardly any inquiry in this country. So neither the state inquiry, state Human Rights Commission goes into, National Human Rights Commission cannot go into. Rarely a matter comes to the court, and the court doesn't know it. Their first habeas corpus petition filed in 1980 could be disposed of finally by the Supreme Court in 97. 17 years. Now that is no justice. Certainly such a long delay in disposing of a petition. And now when the result comes, the two mothers have filed a petition. One mother is dead and gone. And now, of course, now this is no justice at all. There is no justice in a situation like this. So we demand that National Human Rights Commission must be more effective. And I think, of course, the government appointed Justice Amadi to suggest amendments. Some amendments they have suggested not very satisfactory, but I think even that is not being considered. The government is not considering anything of the kind. In fact, if you see the original National Human Rights Commission, it came at a time when the United Nations Human Rights Commission would have passed strictures on the government in 1994-95, because what happened was large number of atrocities in Kashmir and other places, and strictures were being passed, and therefore the government said, no, don't worry, 93. Government said, no, we are appointing a Human Rights Commission which will do everything, and we came back, and unfortunately the Human Rights Commission is not functioning properly. Again, in all this Human Rights Commission, what we find is persons who are committed to human rights are not members of the Human Rights Commission. The constitution of the Human Rights Commission, as also many other things you will find, it was drafted in such a way as to accommodate some of the retired judges of the courts. That's all. Under the law, Protecting Human Rights Act, the chief chairman of the National Human Rights Commission shall be a retired chief justice. Why? What is his commitment? No, but he shall be a retired chief justice. And then again, another member of the National Human Rights Commission shall be another judge of the Supreme Court. Why? So there is no reason as to why. Only because a judge. How many cases of human rights these judges have done? No, nobody bothers. This is the constitution. The third member shall be a retired chief justice or a judge of the Supreme Court. Okay, this is how the Human Rights Commission is constituted. So the State Human Rights Commission, the chairman shall be a retired chief justice of the local high court. And then the other member shall be a district judge and so on. So why this kind of thing? I don't understand. Human Rights Commission must be bold enough to inquire into what the government is doing and not doing. Human Rights Commission must be bold enough to pass strictures of the government, take action against the government, and suggest must be an effective remedy. But unfortunately, it is not. It is not. Of course, some attempt is being made to innovate in its own way, but not very satisfactory. One of the things, of course, that the Human Rights Commission can do is that whenever a complaint comes, it can ask the party to go to the court with an assurance that the Human Rights Commission will intervene in those matters in the court. This one is what can do. But how many matters the Human Rights Commission will intervene? Hardly one or two. National Human Rights Commission intervene only one or two matters. Though that's the provision. They can always intervene in the legal proceedings, come to the court and say, well, we support this. We support this kind of action. We support what is done, what is we say, what is the government is wrong. No. Powers are there to appoint commissions under the Human Rights Commission itself for the purpose of inquiry. For example, from Delhi to come to Manipur is not easy for any inquiry. What the Human Rights Commission can do, authorize the local Human Rights Commission or a member of the local Human Rights Commission to act and give powers, delegate powers to this particular officer or member to do some kind of human rights work can be done. But of course, that is called ingenuity. But that is not being done. This is one. The third thing which we noticed was the National Human Rights Commission has not bothered to visit this place even once for the purpose of holding an inquiry against atrocities. Okay, they may not be able to take action against the army, but they can certainly hold an inquiry into what is going on here. What we have done, for example, we went and talked to people. We met people, a girl who is raped, a person who is tortured, a person who is paralyzed. We met and talked to people. The Human Rights Commission can come here and do it. No, they are not doing that. They have not done that. So it is in this sense we feel regretted that the Human Rights Commission, of course, for namesake, we have a National Human Rights Commission and nothing beyond that. This is the unfortunate situation. And I think it's a long way, it's a long struggle. All these human rights issues are going to take its own time. The third thing which I want to tell you is the craze on the part of the government and government agents to think that they cannot solve any problem unless they have a harsher law. I still remember I was invited for a meeting for police officers, home secretaries, organized by the Tata Institute of Social Science, where I was asked to give a lecture on Tata law. As I told you, it was the most draconian law. And so one of the officers said, sir, without a harsher law, without a strong law, we will not be able to control the situation. So I posed a question, what do you mean by a harsher law? What do you mean by a stronger law? Does it mean law which gives power to cut off your limbs? Okay, police officer gives power to cut off your limbs. Okay, you want that kind of law? As in some of the Middle East countries they have. You want that kind of law? He said no. Then what do you mean by harsher law? Harsher law means I can arrest, but I do not produce him before the magistrate. Harsher law means I can arrest and torture him and accept confession. Harsher law means I can arrest and see that he is not given bail. This is the kind of harsher law they want. And they think without a harsher law, we will not be able to control the situation. Now this is a psychology. I pose a question when you say harsher law, but who administers? You are the people you are administering. We have the Indian Penal Code. We have the Criminal Procedure Code, which gives all powers. Case of murder, case of truculence, case of robbery, case of conspiracy, case of sedition, whatever be, you can take action under the Criminal Procedure Code. But you have failed because of your inherent weakness. You have failed because you are not a field chief. You have failed because you have not been trained how to investigate. Today our police only know one method of investigation, namely what? Torture. You have seen some Hindi films, I don't know, similar Manipuri films are put there, where an accused person is taken to the police station and the police officer hammered. Now this is not imaginary, it's exactly what goes on inside the police station, and these are true. But our police are only trained there. They have not been trained in the proper method of investigation case. They only beat, hammer, and then get some statement, and that's the way they think they have to conduct the investigation. Now this is beyond this, they don't know. So they feel without a harsher law. That's why when Tata law was withdrawn, in the sense not allowed to be renewed in 1995, because public protest was large number of us have protested, number of meetings were there all over the country, and that is how they withdrew the Tata law. Soon thereafter, the police started a campaign. In Bombay, for example, there were series of encounters, and they said, all this is because we don't have a law like Tata. But you see the encounter days, most of, as you see, our human rights groups have inquired into, they are all fake encounters. And people are made to believe, as somebody said here today, as also I think in the letter which Kennedy received, people are made to believe this kind of law is necessary. People are made to believe the police are justified in having these encounters and killing people because somebody is killed. Immediately the next day it comes to the press. A member of the Chota Shekil gang killed by the police. And then of course we don't know, is he really a member of the Chota Shekil gang or he could be an innocent man, we don't know. If another person is killed in an encounter, again what the police said, same thing, namely he belonged to Dawoodi Ibrahim gang and therefore is killed. Or he belonged to ISI and therefore is killed. He is killed, who decides who is a member of the gang? Tomorrow it could be your turn, what happens to that? Then you also will describe that you belong to a Chota Shekil gang. Now this is the problem, and therefore the police are create this psychology, and people are made to believe that unless CRPF men go and kill some people, okay, you can't control insurgency. Our so is killed because he described already. Police have no right to judge. Police only power is to arrest, detect a case, arrest a case, arrest the accused, investigate, bring a charge sheet. It's the duty of the judge to decide. Not the police themselves are given the power to investigate and also power to decide. Then of course there will be no justice in this country. Now, the police and the government feel that we want this kind of after law, and as a result of that, after nearly 5 years, now again they have brought this law, the Prevention of Terrorism Bill, which is now pending in the Parliament. Some of the state governments already brought that kind of law. Tamil Nadu brought a law, Prevention of Terrorist Act, because they have withdrawn the other day after 2 years, because in Coimbatore there are some bomb blasts. Immediately they felt, these bomb blasts have been organized by some ISI agents, and therefore we won't have this kind of law. Our Maharashtra government has brought a law, it's called Syndicate Act, almost identical, of the same line as the Prevention of Terrorist Act. Now why they have brought this kind of law? Again with the same feeling, without this kind of law, they cannot investigate. Now this is fundamentally a wrong concept, because the harsher the law, which denies basic liberties, which denies basic human rights, the police will become more autocratic, and that the result, with the result, it will be nobody knows who can be arrested, who can be shot dead. This is what will happen. Now, with the same kind of psychology with regard to Armed Forces Special Powers Act, I don't understand why should Army be given these special powers. Power to investigate is already there in the criminal procedure court. Of course, it is done by the police. Okay, local under the constitution, as also under the ordinary law, if the police want assistance, they can always recruit more policemen. They can always send us. Local government can tell the central government, look here, there is an internal disturbance such, our police are not adequate enough to control the situation. We want your assistance. If what the central government send paramilitaries or the army, when super cyclone relief was asked for, disaster took place, what happened? The local administration could not manage. They sought the help of the army. Army was sent by the central government to give relief and work in a disaster as a part of disaster management plan. When Bombay riots broke up, as I said in 1992, the central government was asked to send the army. Army was sent, but not under this Armed Forces Special Powers Act. So today, this Armed Forces Special Powers Act is again the same psychology. Unless we have this kind of law, we will not be able to control the situation. This is against all the spirit of the Constitution. It is against all human rights. And this is the main problem as far as this city is concerned. This act, with this power, you are giving power to an army. Army which is trained to kill. Because that's a basic training. They are not trained for anything else. They are only trained how to carry the battle. Now you send them to an area, a civilian area, and you give them ample power and tell them do whatever they like and nobody to question them. Because Section 6 says you can't question it, you can't prosecute, you can't do anything. Of course, they consider they are law unto themselves. And this is the kind of thing that goes on. And that is how armed force, wherever the Armed Forces Special Powers Act has been applied, this kind of atrocity has taken place. All of northeastern states, day in and day out, we hear these atrocities. And I think that is what we are fighting against. We don't want this kind of atrocities. Of course, at the same time, we do want peace in this area. Because essentially, it's for the people. Very often I pose that question. If people have, some of them have become extremists, why? Are they really criminals or are they for something else? Why have they become like that? In Kashmir you go, why people are taken to arms? We had no problem in Kashmir for about 20 years or more. Till about 1980, we had no problem at all. In the sense, of course, states, but by and large, within Kashmir, we had no problem. But why did this problem arise after 1980? These are things which have been considered serious. And of course, the government doesn't bother about it. The government takes, with a superior power, they can control. And for example, Andhra Pradesh, I went to Andhra Pradesh, where we have people who are grown. I posed a question to some of the people, why people war group has come there? Why of course they do kill, we don't support killing, but why they have come? Why they have taken to arms? What is the reason for that? Please find out. If you find out that, you get an answer to that. You don't want to find out that. You only think, if they have taken arms, we kill them with superior powers. And the killing goes on. Actually, that's what happened here. In all places where such draconian laws were introduced. Tada law did not minimize the terrorists. Tada law increased the number of terrorists. Even in spite of Tada laws being there for about 11 or 12 years, number of terrorists have not come down. Number of bombers have not come down. It's continued. So also the Armed Forces Special Powers Act is here for the last 20 years or more. As far as the whole of Manipur is concerned, the extremists have not come down. The number of groups have increased. So you think the more army, more terrorists, and more this kind of repression, it means negation of all human rights, negation of all liberties, and of course this becomes an intolerable situation. And actually there is one other thing which we have seriously considered, and that is we have in the Constitution, sir, this is one of the unfortunate things. So also in our criminal procedure code, as I've been saying, wherever killing takes place, what should be the answer? If a man was killed, he should be prosecuted for murder. Of course, here he can't be, because that's a primary charge against him. He may defend himself. Under the criminal procedure code, you see, what happens is, if there is a riot and there is an inquiry to be ordered, after a riot results in killing, the inquiry again is an executive magisterial inquiry, not a judicial inquiry. There is no provision for judicial inquiry in the criminal procedure code. Now this is an unfortunate thing. And therefore, we have been demanding, even under the international covenant, and also if you look into the United Basic Principles for law enforcement agencies, you look into that, explicit provision is there, namely, wherever such killings have taken place for the control of the riot, in the name of public order, if a killing takes place, there shall be a judicial inquiry. What is important judicial inquiry for every killing? And it should be a part, not that government will appoint a commission inquiry. It should automatically, a killing takes place, there shall be a judicial inquiry. Judicial inquiry means the man has to be first charged, arrested, kept separate. He can't be a part of the administration till he is cleared by the judiciary, by the judge. He can be prosecuted, he may come and say, I have to kill this man. If I had not killed, this man would have killed me. Okay, the court may accept it. Otherwise, court may say you are guilty and he has to be prosecuted, he is convicted. That kind of inquiry is a must. Unfortunately, we have still not amended the criminal procedure code. We have been demanding in our report, I have mentioned expressly in some of my reports, that in all such cases, there should be a judicial inquiry wherever killings have taken place. This is one. And the second thing is, we have essentially a detention law under the Constitution itself. Initially, when we drafted the Constitution, we felt, of course, Article 20, 21, right to life and liberty and so on. But at the same time, we felt, we can't give too much freedom to people because anything can happen. So we thought there should be a provision for detention, Article 22, clauses 4, 5, 6, 7, 8, and so on. Things how a person is detained. Now, this detention law was initially at that point of time, perhaps, there could be some justification because a partition taken place. Large number of people have come from Pakistan, and this kind of conflict was there. Exodus from one country to the other resulted in large number of problems. Perhaps they wanted some kind of law. But to continue the detention law today, I think is one of the worst things that has happened in this country. People are just arrested and detained. Of course, now under the constitution we are given some kind of safeguard. What is safeguard? One safeguard is, if a man is arrested, he must be given the grounds of his arrest within a period of 5 days. Of course, sometimes it's given, sometimes not given. And then, of course, the other thing is, there will be an advisory board consisting of a sitting High Court judge today, earlier it was not there, after amendment, a sitting High Court judge and 2 retired High Court judges for scrutinizing the papers, whether detention was proper or not. And if the detention is proper, of course, then detention board recommends detention will continue. Then, of course, the individual, the person concerned, can file a habeas corpus petition and the matter may be decided in High Court, he may be let off and so on. Point is, today, we have a Inter-Security Act and many detention laws we have. Under detention law, people are just detained and we don't know. The advisory board, I can tell you, I am a member of one or two. I was a member of 2 or 3 boards. I resigned. Now still I am a member of 1 board. And what do we do, I can tell you. It's never reported anywhere in the press. It's never reported anywhere in any textbook or anything. How does the advisory board function? I can tell you from my experience. What do? We call for the records. And what do the records show? The records show the officer concerned, the detaining authority. He says, I have the following statement of witnesses. All the witnesses said this man is indulging in this, and I am satisfied that this man is required to be detained under this law, and therefore I pass this order. Now, witnesses are not called for questioning before the advisory board. Witnesses are not examined before the advisory board. Witnesses may be true, false. Sometimes they say the man is so dangerous and we can't disclose the name of the witnesses, so we don't even give the name of the witnesses. Name of the witness is not given. So the advisory board, so what we do is, okay, whether the officer concerned who passed this order, whether he has a sufficient material before him to arrive at his subjective satisfaction. This is what we say. Objective materials to arrive at subjective satisfaction. Whether he had sufficient material before him to pass this order. Okay, yes, half of the statements are there. Okay, we say we have material before him, true, false or otherwise, one doesn't know. So we accept that. And then say, detention is okay, detention will continue. Because the man has lawyers, he has money, he goes, otherwise he suffers. Poor people suffer, they can't go. They are social worker, you are a social worker. Tomorrow government will say you are danger to security. Put you behind under the detention law. And this is what is going on in a number of places in the country. Under the detention law, there are different kinds of detention law. Say, for example, in Bombay we have one slum law, preventive slum law and bootlegging act. You are described as a slum lord. Maybe you may not be slum lord, you are an activist in the slum area. They want to prevent you from functioning. They will just put you under a slum lord act and you are detained for 1 year. What do? You go to the court, the advisory board, okay, the materials are there, and you are detained effectively. You go to the court, you have to spend money, you have to engage a lawyer, then of course the matter takes its own time. By the time the detention gets over, this kind of thing is going on, and it's time. All human rights groups must demand the provision in the Constitution. If you amend the Constitution many things, nobody will say nowhere, no government agency, not anyone has said, please cancel the detention provisions. We have been demanding that. Our human rights group have demanded. It's time now to scrap up those provisions, providing for detention without trial. It's against universal human rights. Namely, you can detain a person without a charge. You can detain a person without a trial. No person can be detained unless there is a charge and required to be tried and there is to be trial. You just can't detain a man without a trial, without anything. You just kept inside. This can't go on after 50 years of independence in this country, and therefore it's necessary those provisions will have to be scrapped off. I think human rights group must take it up seriously, and the provisions in the constitution which relate to detention must be scrapped off, and that is a must. And of course, lastly, under the Tara law, as also under this Act, now what has happened is, under Tara law, once an area is notified as a terrorist affected area, then of course anybody can be arrested if he is found with a lethal weapon. Now you must have heard of Sanjay Dutt's case. Sanjay Dutt was arrested in the bomb blast case for what? Because in his house there was a gun. Because of course he's a spoiled chap, and he got a gun. He kept it for the heck of it or whatever it is. But he was charged. Not that he was a part of the conspiracy of bomb blast, nothing to do. But he was found in a notified area with a gun. And therefore, tomorrow you could be found with a knife. You can be arrested under Tara law. And notified area means terrorist affected area. Now you'll be surprised to see Bombay was notified as a terrorist affected area. Bombay city, where we had a normal life, never any terrorist activities or anything of the kind. Yet Bombay was notified as a terrorist affected area. Pune was described as a terrorist affected area. Number of cities, peaceful cities. People go for films. In Bombay we have night show, 9 o'clock. It goes on 12:30, 1 o'clock. And come back. Absolutely peaceful place. There is nothing, maybe there could be some murders which take place everywhere. Killings take place everywhere. But yet it cannot be described as a terrorist affected area or a notified area. But the government just notifies, and then of course you are found there, you can be charged under Tara. The same thing here under the disturbed area. So how do you describe an area as a disturbed area? What disturbed area? In Impala city, how do you call it as a disturbed area? Disturbed area can't be the whole of Manipur state. Disturbed area could be some pocket here or there where the disturbance is such that no public member can live. That's a disturbed area. Disturbed area is such that no peaceful life is possible in that area. That's a disturbed area. Where life is peaceful, ordinary day-to-day life activities are going on, how do you call it a disturbed area? I don't understand. Under this Act, unfortunately, there are no guidelines. They just notify it as a disturbed area, and then of course with powers to kill within that. I've already said power to kill is, according to me, prima facie unconstitutional against Article 21, and the court should reconsider judgment. So also this, I gave a disturbed area. This was argued in the Supreme Court in this case, and Supreme Court said no, we don't adopt guidelines. We are satisfied with the subjective satisfaction of the government. What do you mean subjective satisfaction of the government? It's patent here. We have been here for 5 years. If we're a disturbed area, we would not have been able to come here. We don't know where we go. We are in a disturbed area. Today, there is no danger for the people. Perhaps there is a danger for the army. Yesterday, David said we are coming, we are stopped in one place. And they asked, of course, Mr. Babu said, there's a judge here. Okay, that's a passport. So we were allowed to go. And who knows, I could be somebody else, I could be terrorist also. But the moment he said, I'm a judge, okay, the officer was satisfied, he allowed us to go. This is the kind of thing. So the officer decides who should be detained, who should not be detained. He doesn't like your face, he can detain you. He likes your face, okay, he will allow you to go. How can such a thing be done? And is therefore necessary. This concept of disturbed area has no justification whatsoever. It's time, it should be, the Supreme Court must lay down guidelines as to, if you want the act to continue, scrap of the act, but you want the act to continue, then of course it must be specifically stated how do you declare an area as a disturbed area. And if your life is peaceful, there is no question of law and order, no question of public or disorder, then of course it can't be described as a disturbed area, and it's time the government understands what we are saying, what we are feeling. And these are some of the thoughts that came to my mind, and I thought I should explain to you some of these things. Of course, I'm quite happy that your laws are active, you have fair good knowledge of human rights. But I think that before I start with one question somebody asked in the morning, what is the first step to be taken by a lawyer in a human rights situation. Somebody asked in the morning. Now, I just want to clarify. I thought I should have done it at that moment. It comes to mind. Human rights lawyers should train themselves to conduct human rights cases. So how to conduct? For example, you want to fight a case of violation of environment. Something where environment violation is taking place. You just go and file a petition, you will dismiss. Narmada case, initially what happened was the same thing. There was one person called P.D. Varghese. You must have heard of backward class commissioner. What he did, he came to years ago, talking of years ago, much before, sometime in 80s. He came there, he saw the dam, mentioned the dam, he saw Adiwas people are being thrown out and also things are happening. So he felt very bad about it. And so he went to the Supreme Court, filed a petition on his own, saying this Narmada dam is interfering, people are being thrown out and there are no proper construction, should be stopped. Now, that petition came before Justice Ranganath Mishra, who became later on the Chief Justice and also later on the Chairman of the National Human Rights Commission. Now, he kept a petition, kept it pending, made it returnable after about a month, notice was issued to the government and others. In between, what happened was, Justice Ranganath Mishra was taken to the dam site. He came to Gujarat. I don't know how whether he was invited or came on his own. And he was taken to a place called Kelewadi. I think that's what the name of the place. Kevadia. Yes, Kevadia. There's by the side of the dam. There's a place, a beautiful place it is. I've seen it. Kevadia. He was there by the side of the river. He was brought there. Nice atmosphere, beautiful river, greenery, surroundings, everything. The judge was quite impressed. I don't know who all met him, all impressed upon him. So he went back. And when he went back, he kept the matter on his board. And he told Mr. Varghese, I have gone and seen the place myself. You don't have to worry. Everything is being taken care of. The builders have assured that they will construct the dam according to law and according to directions given by the tribunal. So you don't worry about it. And saying that, he dismissed the petition. And he said, the construction dam shall go on. These are the words he added. He dismissed the petition saying, I am satisfied with what is going on and the construction dam shall go on. Thereafter, the Veda Patkar and others, when they realized it, they were not parties to this. Varghese had not prepared the brief properly. He just filed a petition and this is the issue that took place. And thereafter, whenever matter went to the court, each time the dam builders called Jayaprakash Associate, they would show that order. Sir, construction dam shall go on. Don't that injunction. You may do the petition you want, but construction dam shall go on. So it went on till about 80 meters high. Then of course, finally 94, somehow the court felt, okay, we'll again look into it. That's how again, of course, presently the petition is dismissed. What I'm trying to tell you is, in human rights case, you are going to the court, prepare yourself well. You say, in environment issues, have a studied report. Maybe a group like us, an expert group, collect material, go. Similarly, in other violations, human rights violations, you have to prepare well. You just can't go and file a petition. Perhaps, okay, maybe in the case of disappearance or the case of something, but then very often what happens is, your preparation is not enough. And then once you lose, then you get a setback because you have no support on your own. Because in human case, you do it voluntarily. People who have suffered human rights violations mostly are poor. They can't afford to pay you.